Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, we're going to talk about permit to purchase again. And if you're living in a nice red state that lets you live free like American, this video might not do you any good. If you are in a state that has this, or you're in a state that might think about getting it, you might want to pay attention. We're not going to talk specifically about it today. We're going to kind of take a step back, take more of a 35,000 foot view of it. And we really do need to ask ourselves this question. It's kind of the entry-level question to this whole topic. And the question that we're going to talk about today is, can government make you pay for a right? Okay, hey, before we get going too far down the road we're going down, proud to announce that this video is being brought to us by our good friends over at the Sonoran Desert Institute. That's right, get ready to launch your career in the firearm industry today. Get ready to start arming yourself with education today. And most importantly, get ready to start defending the inalienable rights of millions of Americans nationwide, all through our most powerful act, which of course is education. Listen, SDI's got a program, a certificate, or a degree for just about anything that you may desire. So for more information, you can either check them out in the description box below, or easier yet, just visit them at sdi.edu. Okay, America, as you probably now know, we have several states that have either implemented or are about to implement permit to purchases, translation, a government permission slip before you can exercise a right. A permission slip which is not free, by the way. So you're paying to actually obtain a license and then you can go exercise a right. Now, has the issue of pre-purchase firearm permits ever been addressed by the Supreme Court? No, of course not, because if it had, we would all know that one off the top of our head. So I had to do a little deep geeking around to try to take a look at, have there been other instances in the history of the United States where government attempted to condition a license and a cost on the exercise of a right? And the answer is yes, we have as a country done that in the past, and yes, there is case law on that. Now, the two cases that we're going to talk about today are both First Amendment cases, which I recognize might be a little bit apples to oranges, but at the same time, let us also consider that we are talking about inalienable, God-given constitutional rights that were given to us by our Creator, and the Bill of Rights merely says that government cannot take these from us. The first case is a case called Murdoch v. Pennsylvania. It was decided way back in 1943. The facts of the case were some Jehovah's Witnesses were running around Jeannette, Pennsylvania, trying to sell some of their religious literature. The city of Jeannette came down on them, said, no, you're actually engaged in commercial activity. We have the right to license that. We have the right to condition a price on that license. And therefore, unless you get licensed, we're not going to let you run around the community trying to sell your religious literature. What did the United States Supreme Court have to say about that? The following: a state may not impose a charge for the enjoyment of a right granted by the federal Constitution. Well, that seems pretty clear, but unfortunately, as you go through this video, you will see that the waters begin to get murkier as we go. Now, the next case, a case that also is a First Amendment case, and a case that we've actually talked about once before on this channel, is the case of Shuttlesworth v. City of Birmingham. It was decided in 1969. This involved an African-American pastor and many other members of the African-American community who wanted to go out and publicly march and protest in Birmingham, Alabama in the late 1960s. It did not work well for them. The city of Birmingham had a permitting process. Of course, no one had gone through the permitting. And ultimately, multiple individuals were charged and ultimately convicted of a crime in Alabama, which was engaging in a march or protest without having the required permit. The appellate court in that matter ultimately overturned the conviction, but then the Alabama State Supreme Court got their hands on it and reinstated the conviction. On appeal to the United States Supreme Court, however, the Supreme Court held a law subjecting the right of free expression in publicly owned places to the prior restraint of a license without narrow, objective, and definite standards is unconstitutional, and a person faced with such a law may ignore it and exercise his First Amendment rights. Okay, now I know a lot of you want to get caught up on the last part, which is like, that's right, I'm not going to comply, shall not be infringed, I'm not following these laws. And we always tell you here at Washington Gun Law, we ain't going to tell you how to think, we're just going to give you all the stuff to think about. But But then you begin to see some of the other language that the United States Supreme Court used in kind of carving out potential exceptions to this licensing, such as narrow, objective, and definite standards. So it would appear there that the United States Supreme Court actually said that some type of licensing, if it fell within that very narrow exception, could be permissible. Okay, then we went back in the history book and said, well, was there any other times that we tried to condition a cost, an expense on the exercise of a constitutional right? And to no one's surprise, yeah, we have done that as a country. It was called poll taxes. Now, these were created post-Reconstruction era following the Civil War, when candidly some states were not too thrilled with having freed slaves get to vote in their elections. Poll taxes were ultimately challenged in the United States Supreme Court in 1937 in the matter of Breedlove v. Suttles. However, the Supreme Court found that they were totally constitutional. That practice continued for many, many years, obviously suppressing vote, to the point where it got so bad that in 1964, the United States government passed and ratified the 24th Amendment. The 24th Amendment is in the Constitution to prevent poll taxes, but even though they passed and ratified a constitutional amendment, some of the states either didn't get the memo or decided they were going to do it anyways and kept doing it, which then, of course, led us to the case of Harper versus Virginia State Board of Elections, a case decided by the United States Supreme Court in 1966 that said absolutely, positively, and without any question, poll taxes is an unconstitutional barrier to the right to vote, and they are absolutely, positively unconstitutional. But not satisfied with all of those answers, I decided to do some more geeking out and read several law review articles and other articles, and some of them actually contained intelligent information. One of the things that sometimes those on the progressive left, those in favor of civilian disarmament, will argue is that, well, you have to get a license for a lot of other things. And some of the examples that they like to use are driver's licenses, building permits, professional licenses. But you see here that none of those are actually a constitutional right. Believe it or not, you do not have a constitutional right to a driver's license. It is a privilege. It is not a right. I don't have a constitutional right to my bar license. It is a privilege that I had to earn by obtaining an education and passing an exam, paying money every year, and behaving myself. And for any of you in the construction industry, you know that building permits will have more conditions attached to them than one could possibly imagine. But that is totally permissible because we don't have a constitutional right to any of those. But then here's this one, marriage licenses, because we do have a constitutional right to marry, and under Hodges v. Obergefell, we actually have a constitutional right to marry any human being we so desire, even if they happen to be the same gender. And yet, in order to legally marry in just about any state in the United States, you are going to go through an application process and you are going to pay a fee for a marriage license. So, America, can government actually charge you a fee and require you to get a permission slip before you exercise a right? Probably not, but is the answer as definitive as we'd like it to be? No, it isn't. And certainly there is at least one constitutional right, the right to get married, that clearly does require a license in almost all jurisdictions before you can exercise that right. So this is an issue that we're going to start seeing more and more litigation on. We're going to see more and more litigation because more and more states are doing this. And ultimately, this is an issue that may need to be decided by the United States Supreme Court. But ultimately, if you'd like to know where we in the Second Amendment should come down on this issue, if it's not obvious already, I would remind you again from one of the quotes from Shuttleworth v. City of Birmingham, which simply stated, "While the government can require license for certain activities, it cannot convert a fundamental right into a privilege and then charge a fee or require a license to exercise it." So America, I need you to understand that this permit to purchase is not going away. In fact, it's going to start growing like wildfire amongst many of these civilian disarmament jurisdictions. We're going to start seeing more and more litigation about this, and ultimately, this is an issue that likely the United States Supreme Court will have to weigh in on, and God only knows how long that will take. Listen, if you got any other questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. But if you don't, that's okay. That information's down there in the description box. If you got an idea for a video that we should be doing around here, cool. Click on that link right there and tell us all about it. If you want to subscribe to our monthly newsletter, the ability to do all of that is right down there in the description box. And then finally, and most importantly, America, let's remember that part of being a lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.